Good afternoon, everyone.
3 more years to go.
It's great to see you all again. I am Mike Bergman, PILI's Executive Director. I'm standing in for Brent today, who's with us but by Zoom, as well as some other attendees who are participating by Zoom. Today's session is how to be an effective advocate, a view from the bench, and we have some amazing judges who are joining us today to provide that perspective from the bench, and I will introduce them momentarily. During the session, as I said, we've got lots of food for those in the room, so if you want to go back and get another slice of pizza, don't hesitate. I'm going to put in the call for everybody, just to remember about RSVPing. When we have you come in the room, we want to make sure we can feed you and we don't run out, but we also don't want to waste food. So we appreciate those RSVPs. When Brent sends the call out, please do so. We understand sometimes you're going to be in court or in a meeting and you might run late. Don't let that stop you from coming. We have no problem if you walk into a session late. We totally understand you are working while you're doing all this. There will still be food ready as long as we have enough RSVPs. So please just help us out with that. And now I'm going to introduce our panel. Our first panelist closest to me is Judge Patrice Ballread, an associate judge here in the Circuit Court of Cook County. She began her career as an associate at Washington, Kennan, Hunter, and Samuels in Chicago, and then served in the Cook County State's Attorney's Office for 14 years. She was the first Black Illinois Deputy Attorney General for Child Support Enforcement under Attorney General Lisa Madigan. In 2008, she was appointed as an associate judge in Traffic Court and then Domestic Violence Civil Division. She is currently assigned to the Housing Court Division, where she hears matters concerning building code hearings and violations for the City of Chicago and Cook County and reviews administrative hearings. Judge Ballread is a graduate of the John Marshall Law School, as it was then known, now known as the University of Illinois Chicago School of Law. At the opposite end, farthest from me, is Judge Edmund Chang. In December 2010, Judge Chang was unanimously confirmed, which is now a feat in the United States Senate. Back then,
it was easy back then.
It happened, and in no doubt because of how eminently qualified he was, as a U.S. District Judge for the Northern District of Illinois. When he began his service in early January 2011, he was the youngest federal judge in the nation. The youngest?
At the time.
At the time.
Not anymore.
Not anymore.
Thanks for rubbing that in.
No, well, it's funny because I have, I've known you long enough. I had your bio going in my mind, and I think I've always focused on my next sentence. Judge Chang is also the first Asian Pacific American Article III federal judge in Illinois and in any state of the Seventh Circuit. Prior to the bench, Judge Chang served as the Assistant U.S. Attorney beginning in 1991, serving as Deputy Chief of the General Crimes, as well as Chief of Appeals of the Criminal Division. Before that, Judge Chang practiced employment and labor law at Sidley Austin, where, most importantly, he began his career as a PILI graduate fellow from Chicago-Kent Legal Clinic. In 2012, Judge Chang was awarded PILI's Fellow Alumni Award. And then in the middle, Justice Aurelia Pucinski, who was elected to the Illinois Appellate Court First District in 2010 and retained in 2020. She served as the Circuit Court Judge in Cook County from 2004 to 2010. As a trial judge, she heard more than 10,000 domestic violence cases, followed by an assignment to hear adoption, election, property tax, and mental health cases. In addition, she served as the clerk of the Circuit Court from 1988 to 2000 and started practicing law in 1976 in a neighborhood law office where she developed a reputation for her pro bono work. A native Chicagoan, Judge Pucinski is a graduate of DePaul College of Law, and also her undergraduate is from the Catholic University of America. Her and I share that in common. We both went to the same undergrad and the same College of Law, though I am slightly older. And with that, we are going to turn to our panel. We'll go for about till 12:30-ish with questions from me for them to answer. And then I'll open it up both to questions to all of you here in the room, as well as to questions from those on Zoom. Some folks, when registering, took us up on the offer to ask questions in advance. And so I've got a few of those as well. So judges, and we'll start here with you, Judge Ballread. There are several different paths to the bench. Can you go into a little bit more detail about how you personally came to the bench?
As I told Michael, I wrote these things down so I would not forget. So I'm hanging on to my notes. I am an associate judge. The associate judge process begins with the notice being issued in the Chicago Daily Law Bulletin, indicating that there are vacancies. The chief judge can, excuse me, my handwriting is worse than I thought. The chief judge can can, he sends out the notice when there are at least 5 vacancies for associates. Once the notice is listed, anyone interested must submit an application. That's open for about 30 days, and it says it on the notice so that you know what time frame you're looking at. Then you submit your application, and that application is very thorough. So you're talking about the cases you've had, what your careers look like, some references, and information about your health and those kinds of things. So it's a very in-depth application. So probably need to start collecting stuff now. So when you want to do it, you will have that information. After you submit the application, the deadline passes. There is an evaluation process that is through the bar associations. So the bar associations schedule evaluations for all the judges that have not applied in the last 2 or 3 years. So it's usually about 200 people applying or more. So it's a stiff competition, but it's very thorough. And after you finish the evaluations at the bar association level, those are sent to the chief judge. Then the chief judge and the nominating committee that he appoints, which is the presiding judges in Cook County, they look at all the applications, they interview all the applicants that they need to, and then they make what's called a short list. The short list is twice the number of vacancies, so it can vary from 5 to 10 to 20. At one point, there were 31 vacancies. So there were 62 people running around Cook County talking to judges. And so that process lasts, you go talk to over 200 judges in Cook County, so that you present your credentials, you talk to them, let them know you can string 2 words together, not a crazy person. And you do that for about 2 weeks. And then actually the judges vote within a 3-week period. So that's why that first 2 weeks is important. It's an endurance test. The chief judge sets up schedules so people can go and interview and talk to people. So there's various gatherings so that you have an opportunity to at least touch the judge so they can see who you are. Everybody sends in their picture. You're going to send out your resume and your picture to all the judges, and it's full circuit judges. Those are the judges who are elected by the Cook County residents. So you're talking to all those judges, you're going to see them, then they make a decision, they vote, and then subsequently, the chief judge calls you and tells you either got it or you didn't. I applied several times. I was on the short list 3 times. The 3rd time was a charm. He called me on my birthday and told me I made it. And so then I became a judge in 2008.
So at the trial court level in Illinois, we have some appointed, mostly elected judges. Justice Pucinski, could you talk about the appellate court?
Well, I could talk about the circuit court first,
Yep.
right? Because Justice Ballread is an associate judge. If you're going to be a circuit court judge, of course, in Cook County, you could be a circuit court judge from the whole Cook County. And you could also run in a sub-circuit. So when I started in 2004, I ran in my own sub-circuit where I had already practiced law. I was pretty well known. I had good name recognition. Why not? So I did that. Then the next year, the next election cycle, that was in 2004. Then in 2006, I ran countywide. Now remember, I'd already been a countywide elected official. So I had that benefit. And I wanted to run countywide for a couple of reasons, not the least of which was if you're running for office, any office, you're building a brand like Coca-Cola, Hank Schmidt, Harris Bank. You're building a brand and you have to keep pushing that brand out there. Otherwise, use it or lose it, people forget. So I ran countywide and I was very glad to do that. And then in 2010, I ran for appellate court countywide. When you run for office in Illinois for judge, all the judges that aren't associate judges appointed are elected. Now, some states don't elect judges. They have different mechanisms, but Illinois circuit judges, appellate court judges, and Supreme Court justices are elected. And because of the way Illinois is set up, I'm hoping that it changes. You have to run as on a partisan primary ballot. So I ran as a Democrat. I had to convince Democrats to vote for me in the primary. Then I faced a Republican challenger in the general election. I personally believe that judges should be elected on a nonpartisan ballot. It should just be throw everybody's name in, top 2 running against each other in the general election. That's the way it should be, because I think it's fundamentally flawed to have a system where every 10 years, you'll see there's a redistricting of the districts, right? Congressional, legislative. And every 10 years, the paper reports, oh, well, the map proposed by the Democrats won in the Supreme Court on a party line basis, as if the Supreme Court justices are only voting because they're Democrats or Republicans. Wrong. I think that's absolutely wrong. And I hate it when that happens. So I'm a big advocate of nonpartisan primaries for elected judges. Now, running for the appellate court countywide, it's a lot of fun, but you saw me, I was standing in front of the plates at the buffet table. Why? Because I've run in Cook County 23 times and I know that's the best way to meet people if there's food being served. So I love my job. I'm glad that I ran for it. I'm glad that I was retained. And I just want to point out before I forget, I'm going to step out about 5 minutes before the session ends because I have 2 oral arguments this afternoon in the next room over. It's all set up on Zoom. We're doing it by Zoom. And any student that wants to come watch an oral argument can, but you have to be really quiet so you don't disrupt the court because court is in session. But if you want to come watch, you can. And that's my story and I'll stick to it.
Perfect.
I want to say one more thing. We, as associate judges, get reevaluated every 4 years. So we have to go before the bar associations again and present our credentials, and that's how we get reappointed after the judges vote. But we do have to go through the reevaluation process.
So that's a bit of a perspective on how it's done here in Illinois for our state courts. Judge Chang, can you talk to your path to the bench and a little bit more about the federal court?
Sure. Yeah. So my path is it starts really with a shameful cynicism on my part, and what I mean by that is, of course, as you know, for federal judges, it's the advice of the Senate, advice and consent of the Senate, and the White House nominates them. And so I had always thought of this process as being hyper partisan, and I am actually not a member of either party. I have never voted in a primary in my life. I have just always kind of shied away from partisanship, and I'm not an anarchist. Okay, I understand that the 2 primary parties, play very important organizational and magnifying effects, of individuals. There are informational shortcuts that parties provide. Yes, so I'm not in favor of anarchy. However, I just never donated to a candidate, in my life, and so I thought, out of this very shameful cynicism, I have no chance, being a federal judge. It was not even something I was thinking about. Opening came up on the district court in 2008. Right? President Obama was still in the last year of his last term, and I'm sorry, it was the last year of George Bush, the first, his second term. Opening came up, and all right, so an opening came up, and one of the judges for my clerk, though, Judge Marvin Aspen, he called me up and he said, "There's an opening and you should apply." And I said, "Hey, you remember, I'm not a Democrat, I'm not a Republican, and I'm not a Democrat either, but I'm not a Republican." And President Bush had set up the system where, because there were 2 Democratic senators, he said, "All right, well, who am I going to get advice from? I'm going to use the senior Republican Congresswoman at the time, Judy Biggert, who's a wonderful representative from the western suburbs, Northwestern law grad." And so I thought, I have no chance. And he said, "Well, you should still try." And I said, "All right, fine." And so I called the chief of staff, Kathy Leiden, who's a wonderful lawyer as well. And I asked, should I even bother applying? I'm not a Republican and I'm not a Democrat either. She said, no, you should put your application in. So I put my application in, and to my enormous surprise, I was one of the 3 finalists who went out to the White House to interview with the White House counsel's office there. As it turns out, I was not the selected nominee at the time. So remember, this is still summer 2008. The person who was selected is Jay Tharp, right, who was a lawyer at Mayor Brown at the time. So Jay gets nominated. It's too close to the election. It's just too close in November 2008. Obama wins. So Jay does not even get a hearing in the Senate Judiciary Committee, and his nomination just lapses. Now President Obama is in the White House, and there are 2 Democratic senators. And so he asks Dick Durbin, all right, now you give me the names of some finalists. And deeply cynical still, I probably shouldn't have been. I thought, no, there's no way. I was a finalist under the Republican White House, and I called the chief of staff and I said, "Should I bother applying?" They said, "Yeah, we remember you." as one of the finalists, you should put your application in. And I did. And then I was nominated. All right. So that is a lesson in, you have to go for it. Like Michael Jordan said, you miss like every shot that you don't take. And I was deeply, deeply cynical. I should add that it was not a sad ending for Jay Tharp. He did get nominated a few years later. He is now a colleague on the bench, and President Obama nominated him, right, as he nominated a couple of Republicans. So as much as you hear about the partisanship of the process, Illinois actually has a fairly nonpartisan federal nomination history, yeah, I mean, and like my colleagues on the state bench, we are very sensitive to a reputation of partisanship, and it is very distressing, and it's gotten worse over time. Some of it is our fault, right? I mean, as an institution, some of it is our fault, but our credibility is all we have, right? Like as Alexander Hamilton, when he dissed on us, we are the weakest branch. Like, yeah, we are weak. We don't have the power of the purse. We can't print money. We have to go to Congress for money. We don't have the power of the sword. Right? We have no executive officers for us. They're the Marshal Service, all those executive officers who execute our orders, executive branch, right? So our credibility is all we have. And I do fear that it is eroding.
And Judge, I haven't actually read the congressional record from your hearings, but I would imagine the fact that you were a PILI graduate fellow was the center point
Absolutely.
of what was discussed.
Right. Both sides.
The judiciary and the full
was
Senate.
a bipartisan, they
Just
said
a
there's no
quick
need to
plug.
ask any questions.
It's a good thing to have PILI on your resume. Judge, I'll stick with you for a second, and then Justice and Judge, feel free to chime in. So people often say that, you kind of really get to the experience and learning of lawyering once you graduate and practice law. But what types of kind of skill building things do you think that current law students or recent graduates could undertake that could help prepare them for being practicing lawyers?
Yeah, so for the PILI interns in the audience are listening in, one thing that I did not do in law school that I came to regret was clinic work. There actually were far fewer clinics at Northwestern than there are now. And basically, there was one, and there was a long wait list. I didn't, fight particularly hard to get into the class, and it's for two reasons I regret that. One is, that is pro bono work, right? And I'm preaching to the choir. If you're here, I am sure I'm preaching to the choir. But that obligation to do pro bono work, to give someone representation when they otherwise would go without, that is a responsibility, and it's a privilege to hold a law license. This is one of the responsibilities that comes with it. But the second reason was learning client interaction. Right? That is something that there is no, I would think, no law school class that's how to interact with a client and actually have clients, except for if you participate in a law school clinic. And there's no one size fits all for any particular client. I had to learn that in the PILI fellowship, and in fact, when I was in the Chicago Kent Defense Clinic, when I arrived, and I don't know if PILI actually knows this, but the supervising professor at the clinic was going out of the country for 3 weeks, and he said, "So I want you to lead these law students," who some of them were older than I was, and we have some client meetings set up, and so I had to learn that like trial by fire. And I think if I had some clinic experience, that would have helped in just learning how to deal with clients and just talk with them. So that was one of the values of the PILI fellowship as well. So if you're still in law school, have an opportunity, clinic work.
Justice or Judge, anything to add?
Absolutely agree with all of that. Do the clinic work, get a chance to represent people and talk to people and learn the law of their case. So now every fact situation is different, so you have to pay attention. But also in Cook County, especially if you live in Cook County, it's pretty easy to just find a courtroom to go sit and watch. And you'd be surprised. Some lawyers, like any other profession, like any other group, there's a bell curve. There are some slugs, there's some stars. There are a lot of people in the middle just trying to do their job, do it as well as they can. Perfectly good job. You walk into a courtroom, you're going to see a wide range of advocacy. Some are prepared, some haven't got a clue, some know the rules of evidence, some haven't got a clue, but the more you watch that, the better you get. And especially if you're specifically going to be in a court with a specific judge, a week from now, carve out the time to go watch something that's going on in that judge's courtroom, because every judge is different too. And, you need to know, the first time I had to write an order, I won a case. It was my first case. I won it. And I remember the judge said to me, well, draw your order. And I almost said, I don't know what stopped me. I almost said, don't you do that? I had no idea. I didn't know what an order was supposed to look. I had never paid attention to what the orders looked like what's the language that you use. So one of the older lawyers in the room said, come on with me, I'll help you out. But those are the things that you learn by being there. Then things aren't a surprise. And the last thing you want to do is be in court and be surprised. So go to court as much as you can while you're in law school, after you're in law school, be in clinics and read everything. One thing about being a good advocate, you have to know as much about the other side's case as you do about your own, because you have to fight off the other side's case. So you have to know the arguments that they can raise, the laws that they can raise, the facts that they can raise that are going to screw up your case, as well as your case to screw up their case. You have to know both sides. You can't do it unless you do that. You're kidding yourself, because you're going to get smacked around in court by some lawyer who's been doing this for 20 years, knows exactly what he's doing, knows the law backwards and forwards, and you're a young lawyer, and you've got to know both sides.
This is why I'm always grateful you share your wisdom with both me and with everyone at PILI, because you actually thought to not say, gee, Judge, I thought that was your job. That actually slipped out when it happened to me. And I actually looked quizzically and said, I thought you did that. Don't do that. Don't do that.
Well, I would say be inquisitive, always ask questions, take writing and research assignments so you can acquire knowledge on different issues. Whatever office you're in, find out what the hierarchy is so you know who you need to go to get what you need. Find a mentor and a sponsor, or multiple mentors and multiple sponsors, because now the concept is mentors and sponsors. Mentors are those who help you, give you advice, give you information. Sponsors are those people in the room that can move you forward. So you need to find those kind of people to help you out.
Judge Ballread, let's stay with you, and then the other judges can chime in. So we've given some good kind of broad perspective advice on things to kind of prepare. Let's say you're about ready to walk into your courtroom for the first time. What are some of the do's and don'ts that either somebody with a 711 in the state court here in Illinois or a new lawyer wants to keep in mind to do and not to do before the court?
Well, know why you're in the courtroom. Make sure you understand the issue that you're addressing backwards and forwards. As Justice Pucinski said, make sure you know the other side's arguments, because the judge is going to ask you to refute those because you're trying to win your position. The most effective thing is most definitely be clear, give a clear, concise presentation. The least effective is being loud and continuing to talk when the judge says stop or the judge makes a decision. You got to make sure you're understanding what you're there for. And you're going to be nervous if it's your first time, but try to know that you're going to be calm and make sure you're focused. And as Justice Pucinski also said, go to that courtroom, see what that judge likes and doesn't like, so that you can have that information before you go in so you don't make the misstep.
I would add to that, I mean, obviously you want to be prepared, read the law. If there's a statute involved or some administrative rule involved, make sure you read it, because somebody's going to throw it at you and say, well, what about section D? And you'll be like, what's section D? So you really have to pay attention to that. Also, I think being respectful to the other attorney, being respectful to the court, to the judge, to the staff of the court, make friends with the clerk right away, because the clerks really, they're important in this whole process, and they can really help you out. And there's nothing wrong with going up to the clerk before things even start and say, I'm really new in this courtroom. Could you help me out here? Do you know when my case will be called? Do you know where I am in line? And just make friends with the clerk. the other thing is, besides being well prepared and showing respect to the court, and I'm always afraid to say this, but I'll say it anyhow. If you're a woman in court, don't lose your voice court because you're upset, because it's really annoying. Now, it doesn't happen as often with men because men start out with a lower range voice, but it is true that most women I have observed over 50 years practicing law have a higher voice range. And the more, and watch it on talking heads on the news sometime. Go home tonight, watch CNN or Fox or one of those talking head shows. The women, when they get excited and agitated, have a tendency to talk faster and higher. It's really annoying. So you have to really school yourself. When I was running against Jane Byrne, my dad, who was in politics, said, Pooch, do not remind every man in the county of his wife at her worst. And he meant it as a learning thing for me to make sure that my voice stayed low, slow, well modulated, and concise. And so I'm not picking on the women. I'm just telling you that my observation is it's real easy to start to sound squeaky, and you don't want to do that.
And we could have a whole different session about all the things that men do that are annoying.
Oh, men do that.
Just to clarify.
They often, they'll like tower over some of the women. Some men are just really, really tall and big, and they'll try to intimidate a woman lawyer or a shorter lawyer or a smaller lawyer, man or woman. And that's not right. If the judge is smart, the judge will stop it. But you see it all the time. It does happen. You know, size shouldn't matter. But this happens in court, and the more you observe court, the more you see it, the more you learn how to react against it and prevent it.
Judge, anything to add from your perspective?
Yeah, I mean, I agree with all that. I think, yeah, this kind of sounded abstract, but I'll try to give an example. It is to be reasonable, right, in all that you do and all the things that you argue. Now, that's very abstract. More concretely, it literally means to have a reason for every position that you take. So I've seen newer lawyers, but also seasoned lawyers come in and argue a point, and they just actually don't have a reason to argue it. So for example, I had a discovery dispute early on after I was on the bench, and the dispute was, should the defendant be able to take the plaintiff's deposition for 9 hours instead of 7, like 2 extra hours? And I saw the email traffic back and forth attached to the discovery motion. And by the way, so like everything you put down, like in an email or a letter, it can be shown to a judge at some point. So just, you know, bear that in mind too. But the response was like, you know, no. And like, may I ask why? You know, so the opposing lawyer was trying to be more reasonable and try to engage in a dialogue. Like, no, the answer is still no. And so I look at this and I ask the plaintiff's counsel, why not? Like, we just make it a policy at our firm that we never agree to more hours. That is not a reason, you know, for refusing. And I said, well, given the 9 different claims that have been brought here, and the time period is, you know, like something like 7 years, they'll get the 2 extra hours. And I said, you need to have a reason, you know, for what you're doing. So I think as a new lawyer too, like sometimes you'll be sent in by a supervisor or partner into court, and they're like, oh, make sure to tell the judge and take the position XYZ. It is on you to then make sure that there is a reason for those positions, so that when you're explaining it to the court, you can explain it to the court. And it's very difficult to do, but sometimes you do need to then engage the partner or the supervisor in some more conversation and saying, well, you know, I'm looking at the file and I wonder if this is really a position that we can stand our ground on, and can we discuss that? Because yeah, you don't want to be the messenger that takes the arrow on it.
So PILI's mission is to engage, inspire, and empower those advancing equal access to justice. Each of you throughout your career, whether or not you were a PILI fellow or intern, has embodied that certainly in a variety of ways. Can you talk a little bit more about the social responsibility that you think we have as lawyers and as professionals in providing public service and in serving our communities? And Justice Pucinski, if you want to start, and then the other 2 judges.
Sure. As Justice Chang has said, having a law license is a privilege. Not everybody can do that. You have to go to law school, first of all, pass the bar exam, and then you apply for a law license, and then you have to pass character and fitness. So in a state with 11 million people, believe me, not everybody can do that. So along with that privilege comes a responsibility. You know things that other people don't. you have a skill set that other people don't. And there are so many people, just take Cook County alone, that run into some problem with the law and they're just overwhelmed. They don't even know where to start. So the more pro bono work you can do, the more assistance you can provide, the more clinics you're in, the more of anything that you can do is good. If you're in a court and the judge says, counsel, we need a lawyer for this guy, step up, be grateful for the opportunity. It makes a difference to people. And it is important. When I was doing, Judge Ballread and I were both at emergency order protection court or domestic violence court. And when I was doing those, it broke my heart to see senior citizens come into court. They weren't at the top of the pecking order. There was no way to identify them if they didn't self-identify. There was no particular advocacy for them. And sometimes they're very fragile. Sometimes they have medical needs. Sometimes they have health issues. And it was really frightening to me. So I was very happy to work with the city of Chicago to set up a program that specifically does domestic violence advocacy in the courthouse at 555 West Harrison for senior citizens. They can go to the top of the line if that's an issue for them, if they have a ride waiting, or if they need to get home to take their medicine, or if they've got diabetes and insulin problems or whatever, they can push them up to the front. And I really felt that was an important thing to do. If you see something, do something. It's not like see something, say something. If you see something that you think institutionally, systemically isn't working well for people, try to fix it. Come up with a way to fix it. Start a new clinic. Go get some other people to work on the clinic that you're working on because it's too busy. Do something. Don't just stand there and drift. If you see a problem, do something about it. And believe me when I tell you that in a county like Cook County, there are lots of people who are stuck in the court system for one reason or another and have no idea how to deal with it, and they need your help.
It's important to give back. You don't get ahead alone. You've been given an opportunity to make a difference, so make that difference. As they say, too much whom is given, much is required. Giving of your time and energy to others is very important. Many people can't afford an attorney, so you are providing a good service to those in need. And that's the best part of being an attorney, giving back.
Yeah, I think so sometimes there will be like outright success stories where you represent someone pro bono and you win like outright. You might win a judgment for them or a really favorable settlement, and that's of course an enormous impact on their lives in a very concrete and direct way. But sometimes it's not. You will represent indigent clients who, and at the end, it's not a judgment for them. Maybe the settlement is very minimal, if there is one even, and there's still value in that though, because most clients, not all, but most clients will feel like, all right, I had a fair shot because I had a lawyer, because otherwise they cannot navigate this labyrinth of rules and procedures and substance. But if they have a lawyer, even if the outcome at the end ends up unfavorable, they had a fair hearing. And again, that is that enhances justice as well as the court's reputation for giving justice. So yeah, we do what we can in terms of recruiting lawyers. And for those of you who are PILI fellows and you're heading to some of the big law firms, we will be recruiting you. Recruiting is a euphemism. It's an assignment to represent indigent clients, and so. But just I would urge you to not think of it in terms of, oh, we lost at summary judgment. Yeah, you did, but there is still value.
So I'm just going to flag for our friends on Zoom. If you've got a question, go ahead and throw that in the chat. Brent will make sure that those questions get asked. I'm going to open it up to you all here in the room. I have a whole list of questions that have not yet been asked, but I want to give you all the opportunity, if you've got questions, to ask your own of any of the judges.
Guess we said too much. Yes, questions.
We covered it all, right?
All right.
I have a question specifically for Judge Chang, because you said you were a PILI fellow. How did you kind of incorporate that experience into your pro bono experience working at a firm did that give you kind of a leg up? Did you kind of use that experience at all?
Yeah, it's that client interaction was really important. It was a criminal defense clinic. And then when I was at Sidley, for example, I sought out like habeas petitions. And so I worked on a case in which the defendant had been convicted of 2 murders and had a life sentence in Illinois. He actually was serving a Wisconsin sentence as well. And I'll always remember, it was Hank Marshall was a partner at Sidley who he was a partner on the case. And we had our first meeting, and I had come prepared with like, okay, here are the questions I'm going to ask him, and I'm going to the phone call set up with the prison. It's up in Wisconsin, and he said, "A phone call?" And I said, "Yeah, phone call. Like I arranged it, with the warden's office. Like so proud of myself." And he said, "No, we would go see a client like this in person. So you're going to fly up, to northern Wisconsin and rent a car and go to the prison and meet with him in person." And that was, it was a joyous moment. Just like this is a firm that's truly committed to pro bono, and because of course the firm was going to expend all that. And and then talking to Mr. Dalton about, I think if I had no PILI fellowship experience from the criminal defense clinic, would have been much more difficult. But I was able to get the answers that I needed and kind of build that rapport and get the facts to put the petition together. So yeah, I think that kind of client interaction skill does carry over.
Other questions from the room?
I guess this could be, I believe, for all of you, because I think you've all served both in private practice as well as immediately prior to your service on the bench in various executive branch government roles. I was kind of wondering how each of those contributed more to your experience on the bench, and kind of which aspects of each you found more valuable.
Well, I think that all of us are committed to public service. That's the first thing when you're trying to decide what you want to do with your career. If you make a commitment to do public service, I think you can make the difference. I was Deputy Attorney General for Child Support Enforcement. That's when I found out there are 102 counties in Illinois, and I've been to all of them. So you have to know Illinois is a huge state. You can have great experiences, and you got to get to know people. And don't want to burn any bridges. So when you meet people, make sure you're sincere, make sure you're authentic, make sure you are trying to do the best you can do. And if you got troubles or you got problems or family issues, talk to somebody so you can unburden that, so you're not restricted, and you can have honest conversations with people. So that's what you have to be cognizant of. Public service is definitely important.
Yes, I think public service, it's, you make a commitment somewhere along the line that that's what you want to do. It might be being in a big corporate law firm. You're still serving clients, might be in a pro bono organization like PILI. Doesn't really make any difference. The thing is, one thing you have to understand about whether the client is a paying client or a pro bono client, some of them are really nice and your heart just goes out to them and you just want to do everything you can to help them. And some of them are obnoxious. Like, well, it's no surprise this neighbor is fighting this woman. She's obnoxious. She's still your client. She's still your client. So you have to sort of put that part of it aside and say, okay, what are the legal issues that I can do to represent this person? I think every experience that I've had a lot of different jobs, and I believe that people need to have 2 or 3 different careers in their lives. I think that it's too easy to get into cruise control and take things for granted. But every single job I've ever had has been a great job, and every job that I've had has prepared me for the next job one way or another. So no matter how you start, it's probably not going to be how you finish. Just appreciate every phase of it, every phase of your career. Appreciate it and value it and learn from it.
Yeah, from private practice, there's some substance and some not substance. And I practice labor and employment law. That's a substantial part of my docket now. And so I can draw on that experience. And then also discovery, as a relatively new associate, I had plenty of discovery obligations. And so I think that's helped me manage discovery as well. What's realistic, what's not realistic, and in discovery timelines, and also like setting interim discovery deadlines so that lawyers know that, yeah, you have to hit markers before we talk again. And whereas I think in private practice, when I was practicing, we'd have like this discovery deadline like 10 months away, and everyone just like does nothing, for the first 8 months. Like that's not a way to operate. And then in terms of just not direct substance, I think I again, like this client interaction, when I hold settlement conferences, I sometimes draw on that private practice experience to try to figure out, like, is this lawyer acting in this way because she's trying to impress the client? And that's very important for settlement purposes. Like, who's driving this? Like, is it the client? Is it the lawyer? A combination? Can I put a wedge between them, to get at the right, result? And so, yeah, that's some of the private practice experience. And then in terms of the U.S. Attorney's Office, I mean, there it's just a matter of holding them to the highest standard that I possibly can. And I've told them that, I've tried to refrain. I've only said it one time, and like a month and a half ago, when I was in the office. Like I didn't like that when I was in AUSA, and like, well, yeah, when you were in the office, maybe times were different and so on. So I've only had to roll that out one time, but I know what kind of obligations and resources that the government has, and so I will hold them to the highest standard, just as I did when I was chief of appeals inside the office. And people will come to me and ask questions about, should we try to put in this evidence? How is this jury instruction, and so on. It was like the role was like counselor to the office, and a lot of times I would say, no, like, hold on, time out, don't do this. It's not going to survive in the Seventh Circuit. And so, yeah, I do hold them to a very high standard.
So as I mentioned, when folks registered, they were able to pose some questions in the registration form. Jacqueline from Prairie State asked a question that I think we've touched on a little bit, but I want to ask it, see if you have anything to add, and kind of focus it with something that occurs to me. The question was, what are the best qualities or practices of an effective advocate or lawyer? One of the things that I don't know that I've necessarily heard any of you use the word, but I think it underpins a lot of what you've described, is reputation. The reputation of us as a lawyer, as a practitioner, as a professional, guarding that reputation to me is I think something really critical. What other qualities or practices or thoughts on the reputation piece?
Can I add on that? Yeah. So
yes, please.
I had clerked for judges, and also inside the very courthouse in which I now serve. And so I thought I knew how gossipy judges were. I would see it at the Wednesday coffee get-togethers and the lunches and all that. And when I got on the bench, it is like order of magnitudes more than that. Like the first week I was on the bench and I was going out to lunch with all the judges. It's like, oh, so, one of these cases that got reassigned to you, the lawyer, don't believe a word he says. or positive reputation too. It's like this case, it's in great hands. You could take what she says to the bank. So that reputation gets around, very quickly. And so you might think, oh, how many state judges are there? How many federal judges? What are the chances I'm going to be before this judge, a second time? Well, maybe not a whole lot, but their colleagues will, spread the word, and so we're awfully gossipy, and I think technology has also helped that, because we all have a bench laptop on there. I'm taking my case notes as the status hearing is going along, and I'll write, things like obstinate, and that case note will be there, like disrespectful, and so the next time that case is called, if I don't happen to remember, it's like, oh yeah, this is the lawyer that said this or did that. So that it really is all you have.
Right.
So as a moderator, generally your job is to ask questions, right? But I thought I should come up with one thing that I can pass along from my perspective as my big piece of advice, information. It was that judges are gossipy. We haven't done this program together in a very long time, and I love that was your lead. But it is important, I think, to understand that there is a collegiality behind the bench that is occurring, and that when you do things or don't do things, right, stepping up and saying, I'm just here to cover it, is not a good reason to explain why you don't know what's going on in the case that you're there for, right? I see Judge Ballread shaking her head right away, or we're disagreeing with the judge and then thinking that saying, with all due respect, Your Honor.
No.
Oh.
I knew that would be a trigger. Don't do that. It doesn't sound respectful. What it really is you saying is, hey, you idiot,
Yes.
you got this wrong. And that's what every judge hears echoing through their head when that statement is
Oh,
said.
there's another one. That's a good question, Your Honor. Well, duh.
And even if it doesn't, if it wasn't, it doesn't
asked
matter.
it. I must have thought it was a good question. I wouldn't have asked it, so I don't think.
Your reputation is definitely important. Don't let anybody tarnish it. When everyone says your name, you want to make sure there's good things said about you. Also, documents that you create that you think are important, save them. I'm a paper person. And so years ago, when I was a young lawyer, I had things in the basement, had a flood, lost lots of stuff.
Yeah.
So now when you have documents, protect them, put them away, put them to the side, list of people that you want to contact, make sure you maintain those lists and have a good connection with all those people because you don't want to lose that information. You got to make sure you keep track of all that because you might apply for a fellowship. You might need someone who might write you a letter of recommendation. You want to keep track of all that. So you always keep, and now you have thumb drives. I didn't have them then.
Right.
Now I still don't know what that is, but because I still like paper. But yeah, you gotta keep track of those things because you may need them at any moment in time. And you got deadlines and you want to send things out and people will give you references if you follow up with them and they know what you're doing.
One thing that I think law students often do not do is while you're still in law school, if you have a professor that really just thinks you're great, get it to whom it may concern. I am happy to give a reference for this student of mine because of blah, blah, blah. A lot of times the professors will ask you to write the letter and they'll just put it on their letterhead, but store those up. Because professors, 5 years from now, they don't remember who you were. They don't know who you were. So that it helps you have a good file of people that liked you at the time that they met you. If you see a more mature lawyer who's been in practice for a while, you're in court, you're watching, you say, this guy really knows his stuff. Ask him if you can take him out for coffee. Ask him if you could stop by his office. Ask him a question in the corridor. Get to know those guys because even though they're not technically your mentors, they know a lot. They know a lot of people. They know they can steer you in a lot of directions. And so if you think they're doing a good job, pay attention to that. I have to leave in a few minutes. Before I do that, I just want to point out, and Judge Chang sort of touched on this, social media, very dangerous. Very dangerous. And if you're doing a lot of Instagram and TikTok and Facebook and blah, 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 you might really want to reconsider doing that because it's ultimately not good. And a lot of the stuff that people put on their social media comes back to haunt them. And a lot of people who have social media find out 5 years later that their social media account has been hacked by somebody else. And there's like a clone social media that looks like it was you, but it really wasn't you. It didn't have anything to do with you. Somebody who didn't like you did it. And one other thing that I just want to point out is we do a lot of Zooming now. We do a lot of remote hearings. It's really important to keep yourself like in the frame of mind that you're in court. You're not there in your pajamas. You're not there with your closet door open and your clothes hanging out of your dresser drawer, your bed unmade. You're in court. Have some respect for where you are Zooming. Who are you Zooming to? This isn't your mother. She's, she understands that your laundry is on your bed. This is a judge who's looking at you and thinking, this guy's a mess. This girl hasn't got her hair combed. How is she in my court? So we try not to hold that against anybody. But we are also human. And when we see someone who's really not on top of their game, it's a little frightening sometimes. So, you've got this Zoom camera and you think that, oh, you're the only one who's paying attention to it. Not true. A lot of people are.
I've heard it also is good not to commit a crime while appearing before the court on Zoom.
That's excellent.
It sounds like a joke, but it's been happening. Where, for instance, somebody's driving on a suspended license.
Yes.
They're appearing in court driving
Right.
from Zoom. on
Not a
their
good
phone.
idea.
Not a good idea.
Yeah.
Best not to commit a crime in front of the court.
Right.
That, if you're taking away nothing else, that's the thing to remember. Other questions from y'all?
Don't do that.
When you first joined the bench, this is a question for everyone, what stuck out to you the most? What surprised you the most being on the other side?
It was hard to not advocate. And I was thinking, you paid that person to say that's stupid. What is wrong? And so you have to stop yourself from advocating,
Right.
because you're supposed to be unbiased. You're supposed to listen to both sides. And that was the hardest thing to do, not to advocate, because I had been advocating for 26 years and it was just hard to have to stop doing that. So you learn to take a break and talk to somebody if you're going off the rails. And because court can be toxic. And so sometimes you need to go up and take that break, talk to somebody, listen to some music, play online bridge, which is what I do. But yeah, that was the hardest part, not advocating.
I would say understanding that there are a lot of smart lawyers out there, and there might be an issue where I'm really not the smartest person in the world on this particular issue. So having a chance to have the lawyers talk about it is very helpful. I mean, you know, in judge school, they used to teach us, you don't have to be the smartest person in the room. You've got 2 other smart people there. Pick their brains too. Then do your research, see if you agree with them. So that was one thing that just really stuck out in my mind. And the other thing was, especially at the trial level, you have to make a decision. There are people standing there, they're waiting for you to decide. Don't drift, don't dawdle, make a decision. You know, use everything that you've got going on in your brain, all the resources that you can muster, everything that you've heard, and make a decision.
And if you're
Because
wrong,
you don't
that's
want-
what the appellate
You
court
don't
is
want
for.
cases to go on for 5 years because you can't make a decision, you know, make a decision. So it was very interesting to me that all these people are looking at me and they want a decision right this minute. Like, okay, I can do that, but I don't think I had expected that impact the first day that I was on the bench.
Yeah, I think what surprised me was how isolating it actually can be. Yeah, so like there would be lawyers who were colleagues at the U.S. Attorney's Office and like some big heater case, and I thought like we really can't have lunch together. You know, like it wouldn't be appropriate if like someone saw like from the opposing side. I wouldn't want to see the judge having lunch or having them over to their house. So it has been more isolating than I thought. Now the benefit is to get to know these wonderful colleagues and you have that social circle, but it can be restrictive if you're trying to stay completely above board in terms of the appearance of impropriety.
Justice, if you need to run out, I see it's 5 till.
I'm gonna do that in 1 second. I just want to
Okay.
say one other thing. If you're in criminal court, you're defending people, you're probably really busy. You're running between a bunch of different courts. You got a lot of people waiting for you. In criminal court, the judge is going to enter an order, and it's going to be recorded on an order form that's called a minimus. And I don't know about you, we get appeals all the time. They're wrong. They're just wrong. They don't have the right thing that the person has been convicted of. They don't have the right time in jail. They don't have the right number of days credited in Cook County Jail. They don't have the right fines and fees. They're just wrong. And we get appeals on this all the time, and it's just infuriating. So if you're ever in criminal court, don't be packing up your briefcase while the minimus is getting prepared and then rush out the door read the minimus and make sure that your client understands what it says and that you understand what it says and that it is actually what the judge said. Because what the judge says in the transcript is what is going to control, not what's on this piece of paper. But if the piece of paper is wrong, Illinois state prisons are going to pay attention to the piece of paper. So if it's wrong, you've got to go back and fix it. It takes too much time. It's a lot of pain in the neck. So please make sure that you read the orders that are prepared and that they're a correct understanding of what you think happened in court, and explain it to your client because they hardly ever understand it. Right?
That's right.
Right? They very rarely understand it. So,
Thank you, Justice.
I apologize. I'm going to scoot next door. If you want to join me, you're welcome to, but you have to be quiet.
Thank you, Justice.
Our best to the court. We have a question on Zoom. Brent, do you want to share that with us?
Yeah, so this is mostly for Judge Chang, but if others are willing to answer as well, for Judge Ballread. But in regards to your concern for the reputation of the judicial system as bipartisan, now being revealed as very partisan, and the general public losing more and more faith in the justice system, what do you see as a way to move forward? Is this the responsibility of judges, parties, the public? And this was Audrey Park with a very, very good question.
Yeah, well, there are limits to how much I can say in terms of just my personal thoughts on it. And those limits come from the Judicial Code of Conduct, which I hope we all internalize as much as possible in terms of like, what can we speak out on. So yeah, first there's a practical reality of you have to keep moving forward. Like you can't stop, working in the legal system. And nor can you write briefs in a way that are like overtly, partisan. And so like the practical reality is you still have to, even if you personally don't believe it is true, act as if for your client's best interest that the court is nonpartisan. And then in terms of like, all right, how do we actually move forward? Like, all you're telling me for that part is you got to live with it, too bad. There is a responsibility on us as an institution. Candidly, there are some opinions that I read, some dissents, concurrences that seem like they belong in an op-ed in either the Wall Street Journal, the New York Times, or on MSNBC or Fox News. And it's incredibly distressing and frustrating to read those kinds of opinions. So, what can we do about that as an institution? It's just talking amongst ourselves. The Supreme Court does have a leadership role in this, I think, and I think the Chief Justice has tried very hard. When in the last administration there was a reference to on Twitter, this Obama judge's decision, is outrageous and so on. And the Chief Justice issued that statement that says, we do not have Obama judges, we don't have Trump judges, or Bush judges or Clinton judges. My heart like sang, I was like walking on cloud 9 for the rest of that day because it's like, yeah, that's exactly the kind of message that needs to be sent. And, but otherwise last thing I'll say is just to be candid, I don't know how to fix it. So I don't have that silver bullet solution. It's something I think about probably every day. So I'll let you know when I figure it out.
Judge Ballread, I'm going to ask you to wrap us up kind of with that question in mind, but from your perspective as somebody who's very involved in bar associations, the Illinois Judges Association, the Illinois State Bar Association, both as lawyers and judges, what do you think we can contribute through our bar involvement and service?
Well, I think being involved is the first step. You can join law student associations for the bar associations. You can join as young lawyers. You have to be there and participate, because if you see, as Justice Pucinski said, if you see something, say something, do something. Don't let it go to the wayside, because everybody's voice is important. As judges, we don't have the opportunity to speak up for ourselves. If we see an article that gives us negative press, there's not a whole lot we can do. But the Illinois Judges Association does have a group called the Emeritus Council now, where they are going to try to take the opportunity to step up and say something if they see something that's not appropriate in the press. The Illinois Judges Association also started this year the Pro Bono Committee, which Michael helped facilitate, where we spotlighted judges who are involved with pro bono and supporting that as retired and active judges. So I think it's important to join bar associations. You get to meet people, but don't take on too much. Don't overload your plate. Do things that give you joy, and do good deeds. I think that's important for all of us.
Well, that is both a perfect ending to today's panel and an excellent segue to tell you about next week's panel. So on June 14th, we will be back in this room with food, where everyone who will be here will have RSVP'd. And it will be about engaging with your community, with lawyers from bar associations and boards of directors or young professionals boards, talking about how you can make an impact as a lawyer and throughout your profession. So that's next week on June 14th. On June 15th, you've heard already, if you were at orientation, you got a postcard in your folder, and either today or yesterday, you got an email from Brent. Guess what he asked for? Thank you, you're getting it, you're catching on. Next Wednesday, 5:30 to 7:30 is our annual pro bono celebration. You all are cordially invited to come as our guests for free. It's a great event, it's a great opportunity to meet others in the legal aid and public interest, as well as the larger community. We have to tell our caterer how many people will be there today. So if you have not already RSVP'd, whether you're online or here in the room, please do so. That postcard had it, that email from Brent has it, or it's pili.org/RSVP. Would ask that you do that. And with that, we are done for today. take a slice of pizza for the road. We'll see you all next week. And thanks to our terrific panel.
Take care, be safe.